Hello and welcome to Moneylife. This is Sucheta Dalal. This week, we're going to talk about the judiciary. I'm sure many of you have missed the story about a judge that nobody could understand. And this is not me saying it, it is the Chief Justice of the Supreme Court of India who said it. So here's what he said. Every decision of Justice Sureshwar Thakur that came up to the Supreme Court was overturned. He went on, after a lot more, to say, fortunately, he has retired. This brutal comment from Justice BR Gavai just last week was in connection with appeals filed in a murder conviction by a bench of the Punjab and Haryana High Court. So, the Punjab and Haryana High Court had issued this judgment in October 2024. The bench was headed by Justice Sureshwar Thakur. And the Chief Justice of India, when it came up for appeal, says, fortunately, he has retired. Justice Gavai went on to read an illustrative and completely indecipherable paragraph. It's pointless to reproduce it. I will do a few of them later. But my point is that Justice Gavai's comments were widely reported by the media as an anecdote. Many people were amused. But if you have been a litigant waiting tariq pe tariq for decades in India's courts, I'm sure you didn't find it amusing at all. In fact, it's rather alarming that instead of triggering a serious introspection about the state of judicial accountability and judgments in India, this was one episode reported by everybody and seems to have been forgotten. So take a look at why you need to remember this and understand what it means. Litigants endure crippling delays and prohibitive costs. You know the cost of hiring any good lawyer today. We also know that the judgment takes years and years to arrive. Imagine if, when the judgment finally arrives, it is so convoluted that even the senior judiciary and your own lawyers can't understand it. So either you file an appeal or it's wasted, and the higher judiciary reverts it back for a fresh hearing, leading to more costs and more delays, because it's not as if a fresh hearing is going to get over in a fast track manner. It's going to take the same time, same money, and it may also lead to an appeal. How frightening is this? I mean, think about it. Clear, reasoned judgments are the bedrock of justice. Without them, the justice delivery system turns into a depressing parody of itself. And yet, are there any consequences to this? To the judges? Not in India. Justice Thakur certainly faced no consequences, despite a series of his judgments being overturned or attracting stinging criticism from a range of Supreme Court judges. He rose steadily. He came from a family where his father was a judge. He rose through the district and sessions courts, multiple courts, then was elevated to the Himachal Pradesh High Court, did a small stint at the Punjab and Haryana High Court on the recommendation of the Supreme Court collegium. That is important. He retired in May 2024 and he has got a post-retirement posting as chairman of the Punjab State Commission for NRIs. Apparently, a lot of people think very highly of him, but can't be the people who have to deal with his orders. But isn't it strange that the Supreme Court collegium had no feedback whatsoever of his tendency to write convoluted phrases and obscure legal reasoning, especially when the Supreme Court has repeatedly eviscerated his rulings since 2017. These dates are important. Supreme Court has raised questions since 2017. He retired in 2024. Think about the number of cases that went through him. Here's a list. 2017, Justices Madan Lokur and Deepak Gupta set aside his order in Sarla Sood versus Pawan Kumar Sharma, saying that it was not possible to comprehend. Here's an excerpt. I'm not going to read this fully. We're going to flash it on the screen because honestly, I don't think I can read it. Apposite objections preferred therebefore by the JD/tenant manifesting therein qua the decree put to execution therebefore, not warranting recording of affirmative orders thereon, dash, 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 dash. Please take a minute and read it. Yes, that was the actual text. 2018, Justices A.M. Sapre and Indu Malhotra described a 60-page order as needlessly voluminous. This was Surjit Singh and others versus Sadhu Singh and others. 2020, State Bank of India versus Ajay Kumar Sood. This was a judgment involving disciplinary proceedings by the bank. The case went back to 2013. We are hearing this in 2020. And here's one line. The ire res controversia, erupting inter se the litigants appertains, to findings, adversarial to the workman becoming returned upon charge number 1. Your guess about what it means is as good as anybody's. 2022. Chief Justice D.Y. Chandrachud and Justice S. Dhulia set aside a judgment saying it was incomprehensible. The word comes up over and over again. And they stress that judicial writing should not use complex language to confuse the reader or the litigant. No action. 2022 again. Justices K.M. Joseph and P.S. Narasimha likened his rulings to Latin. In fact, I'm quoting, how do we understand this judgment? Is it in Latin? We may have to send it back to the High Court for it to be rewritten, Justice Joseph said in frustration. The judgment had been delivered 5 years earlier in a property-related matter. Think about the time. 2024. A conclusion from one of his last judgments, and I'm reading, or at least attempting to read a bit again. Consequently, and we're flashing it here for you. Consequently, when thereby the above evident facts rather do not fall foul of the above stated / underlined principles in the verdicts (supra) preeminently, also when thus they do corroborate the rendition of credible eyewitnesses' account vis-a-vis the crime Each ruling meant several wasted years for litigants. Several is an understatement. The entire time would be well over a decade. Appeals, more fees, more anxiety. This is not a quirk. This is a serious miscarriage of justice. And who bears the cost? Only the litigant. Because after the Supreme Court reverts it back, that's the end of the story as far as the apex court is concerned. But this is not delivery of justice. The Supreme Court has shredded Justice Thakur's judgments in open court, but was never followed up by a discussion about the financial and psychological damage to litigants and the time. There was never, as far as I can see, any order that you fast track it or complete something or finished it off. In one case, the judges actually told the litigants, come to a settlement or it will be reheard. Each case was in court forever before being tossed out because that's the norm in India. And believe it or not, Justice Thakur is not alone. Manupatra Academy has compiled a list of cases where the apex court has commented on clumsy drafting that it failed to comprehend. Variety of reasons, a variety of courts. Why did this continue? The reason is simple. Performance of High Court judges is never reviewed. Removal requires near impossible route of impeachment, of proved misbehavior or incapacity. In fact, 79 years since independence, no judge has been successfully impeached, not even in the Justice V. Ramaswamy episode where guilt was apparently proven. As we speak, there is another attempt to impeach Justice Yashwant Verma when huge amounts of cash was found after his office caught fire. It's an attempt. Let's see where it goes. It'll be a first, 79 years. In contrast, major democracies have strong justice systems but have built soft accountability that does not compromise judicial independence. That's the big worry that everybody has. Politicians will appoint judges, they will interfere, and it is a serious worry. We are concerned, we don't want that to happen, but that doesn't mean that nothing happens. So soft accountability is required, and most countries have it. The UK's Judicial Conduct Investigations Office, the US Judicial Councils, Canadian Judicial Council, Australia has judicial commissions, all provide confidential feedback, advice, corrective training when judges fall short in areas such as clarity of judgments. If nothing else, it affects career progression. India has nothing comparable to provide any objective assessment or corrective mechanism. In fact, India's silence is worrying. The controversial system of judicial appointments by a collegium is controversial because it's non transparent. So while it protects the judiciary from interference, it's not without controversy about who is promoted. It insulates the judiciary, but lack of accountability is a consequence, with no mechanism for objective evaluation of judicial competence and basic skills like writing a judgment. Workshops of the National Judicial Academy, yes, we have one, rarely heard, but it's voluntary, has no role in career progression. Judicial Reforms Bill 2020 was a serious attempt to bring some sense of accountability. It had proposed a National Judicial Oversight Committee. Naturally, the entire judiciary did not want it to happen, and it lapsed in 2014 after being introduced in Parliament. So, in the absence of a statutory framework to oversee judicial conduct, allegations against judges are not transparent, not dealt in a transparent manner. At best, they lead to some kind of internal investigation and a quiet resignation. In fact, all of us have seen how this played out in 2019 in the case of former Chief Justice Ranjan Gogoi, who is now in Parliament, when he was accused of sexual harassment. The victim was dismissed and persecuted, her family harassed, and a controversial in house inquiry by a set of judges found no substance in her claims after she refused to participate or withdrew from the proceedings because she said they will not be impartial. A larger inquiry into potential conspiracy against the judge was also controversially closed for want of evidence. This is how things happen when it is such a huge issue. So, all other things like Justice Thakur are considered small or inconsequential. Doesn't matter the cost on the litigant. The absence of prescribed norms, eligibility criteria, selection procedures also creates a perception that it's a closed door affair. Every time a judgment is set aside because it's not intelligible, it's a blow to judicial prestige and public faith in the system, which frankly is at an all time low. More importantly, it's a loss of decades. Courts demand reason clarity from the executive. They parse each government GR, but no accountability or corrective mechanism for themselves when they have a judgment. At the very least, the National Judicial Academy must make writing judgments in plain, comprehensible language a mandatory condition for career progression. You have the academy. It's not happening. And today, you have artificial intelligence tools. You can have structured templates. The AI can actually check your grammar and logic and prevent long winded drafting. Use it. There's nothing wrong. You have to think about the litigant, the person for whom you are dispensing justice. Fortunately, people inside the system have begun to speak up. They have been off and on, but in a public lecture recently, senior advocate Raju Ramchandran urged the removal of judges must be constitutionally anchored and transparent, not just reliant on opaque in-house mechanisms. Other legal experts have repeatedly flagged judicial corruption and the opacity of appointments, especially when well deserving judges are denied elevation to the Supreme Court or sidelined. It's happened at least twice. Some of the best judges who ought to have been in the Supreme Court were not elevated by the same collegium, which is not accountable to anyone. India needs to insulate the judiciary from politics. Yes, that's important. But at a time when its role as an independent guardian of justice, upholding the rule of law, protecting constitutional rights, and ensuring checks and balances is already under a cloud, it needs quick introspection to start fixing what is doable and pay attention to us, the litigants, the largest stakeholders in the justice delivery system. The repeated shredding of Justice Thakur's judgment is not an amusing curiosity to be read, laughed at, and forgotten. It's a mirror to India's judiciary's silence on the matter of accountability. When justice itself is lost in translation, what hope is left for those who try to seek it? And yet, we all exhibit such touching faith in the judiciary. If you agree with what I say, please share this. It affects all of us. Everyone may land up in court at some time or the other, and you want a system that works. Thank you.